The tension inside the Supreme Court was already thick when Michelle Obama entered courtroom 2 in a tailored charcoal gray suit, her expression unreadable, her movements calm. The public gallery was filled with spectators, journalists, and law students, most expecting a symbolic gesture from the former First Lady, perhaps a short statement, a message of unity, nothing more. But what no one expected was a constitutional confrontation that would shake the foundations of legal tradition. The justices, seated in their high-backed leather chairs beneath the grand frieze of justice, leaned forward as Chief Justice John Roberts nodded toward Justice Clarence Thomas. He spoke first. "Mrs. Obama," Thomas said, his tone clipped, "this court is not your podium." Michelle Obama did not flinch. She stepped forward, placed a worn copy of the U.S. Constitution on the lectern, and replied with calm certainty. "No, Justice," she said. "This is every citizen's podium when the Constitution is at stake." A gasp rippled through the room. It wasn't just her words, it was the way she said them. This wasn't a public figure grandstanding. This was a woman who had come prepared to defend a legal position with the precision of a scholar and the composure of a seasoned advocate. Her presence in the court wasn't ceremonial. It was legal. 3 months earlier, the case had erupted into public debate, United States v. Atlanta Freedom Collective, a lawsuit challenging the government's seizure of a cultural education center in a predominantly black neighborhood under an obscure anti-terrorism clause. The administration had argued that the center's refusal to share internal documents with a federal agency warranted an emergency shutdown. No charges were filed. No hearings held. The building was simply locked down. Michelle Obama, who had remained largely silent in political discourse since leaving the White House, shocked the nation by filing an amicus brief on behalf of the collective. But that wasn't the end of it. She requested 10 minutes of oral argument time, a rare, almost unprecedented move for a non-party in the case. The court granted it. Many assumed it was a courtesy. A token. They didn't know she had spent the last 8 years studying constitutional law privately, engaging with legal scholars, and building an independent research archive focused on civil liberties and race-based government overreach. As she opened her folder, the justices noticed it was hand-annotated, color-coded tabs, original case footnotes, historical letters. She had not come to deliver a speech. She had come to argue. "Mr. Chief Justice," she began, "and may it please the court. Today, I ask you not to consider me as a former First Lady or a public figure, but as a citizen invoking the protections guaranteed to every American under the Fourth and Fifth Amendments." Her voice echoed across the chamber. Her diction was sharp, her tone devoid of flourish. Justice Thomas leaned forward, attempting to reassert control. "Mrs. Obama," he interrupted, "we have reviewed your brief. Your interpretation of the government seizure power is novel, and quite frankly, untested. Are you suggesting this court has been misreading seizure jurisprudence for the last 50 years? Michelle looked directly at him. "Not misreading, Justice. But overlooking. Overlooking the historical boundaries set by the founders, boundaries that were never meant to be swept aside in the name of emergency power." She then held up a document, an 1806 letter from James Madison to George Nicholas, highlighting language that described the dangers of unchecked property seizure in civil cases. She pointed to page 9 of her brief, where she had integrated the passage into her core argument. "Emergency powers," she said, "do not suspend constitutional rights. They test them." Justice Elena Kagan exchanged a glance with Justice Sotomayor. Something had shifted. Michelle continued, "If the government can seize educational institutions without a hearing, without a warrant, and without probable cause, then no community is safe. And the historical record shows that the framers anticipated this danger." Her tone remained measured, but the room's atmosphere had transformed. The media had expected a speech. The court had expected symbolism. What they were hearing was a methodical, constitutional defense anchored in originalist doctrine, delivered with the authority of lived experience and scholarly rigor. By the time she concluded the first segment of her argument, citing Boyd v. United States and United States v. Jones, even the skeptical justices had put down their pens and were listening, not out of courtesy, but out of intellectual engagement. The battle had begun. And Michelle Obama was not there to play a role. She was there to make history. Justice Clarence Thomas adjusted his glasses, a subtle signal of rising discomfort. It wasn't that Michelle Obama's words had been disrespectful. Quite the contrary, they had been devastatingly respectful. But layered beneath that calm precision was something more dangerous than emotion, airtight logic. "Mrs. Obama," he said again, leaning in slightly, "you refer to the historical intent of the founders. Are you suggesting that our current interpretation of seizure authority violates original constitutional meaning? Michelle didn't hesitate. Yes, Justice. The seizure in this case, without warrant, charge, or hearing, ignores both the letter and the spirit of the Fourth and Fifth Amendments. The founders feared arbitrary governmental intrusion more than any other domestic threat. They embedded protections against it into the core of the Constitution. She then reached into her folder and removed a photocopy of the records of the Federal Convention of 1787, placing a yellow tab at a passage quoting George Mason, "To seize property without charge is to render the law an instrument of tyranny rather than justice." Thomas furrowed his brow. Justice Alito looked up for the first time since she began speaking. Across the bench, Justice Sonia Sotomayor gave the faintest nod of recognition, not approval, not solidarity, but intellectual acknowledgement. She knew what was happening. Michelle Obama wasn't offering activist rhetoric. She was speaking the language of the court. Fluently. Behind her, the government solicitor began shifting in his chair. He had expected to argue against a symbolic celebrity brief. Instead, he now faced a seasoned interpreter of constitutional text with originalist credentials. "Mrs. Obama," said Chief Justice Roberts, his voice calm but curious, "your brief cites multiple 19th-century state cases that were never adopted by this court. How do you reconcile your reliance on them with stare decisis?" Michelle smiled politely, not triumphantly. "Mr. Chief Justice, stare decisis binds us to precedent, but not to silence. When precedents conflict with foundational principles, it is not disrespect to raise those tensions, it is responsibility." She turned to page 17 of her brief and read aloud from New Jersey v. Crawford, 1843, a case where the state Supreme Court invalidated a wartime property seizure for lack of due process. "The court held," she said, "that no cause is urgent enough to nullify the need for a hearing before liberty or property is deprived." Justice Kagan leaned forward. "But that was during a war." Michelle replied instantly, "Yes. Which is precisely why it's relevant. The court ruled that even in war, due process was essential. The Constitution is not a fair-weather document." For the first time, murmurs began circulating in the gallery. Reporters typing quietly stopped. Law students were now openly taking notes. A CNN legal analyst in the back row leaned toward the camera, mouthing the words, "This is real." Justice Barrett, who had so far remained reserved, finally addressed her. "Mrs. Obama," she said, "your argument implies that the government is exploiting emergency statutes to bypass constitutional limits. Do you have evidence of intent?" Michelle nodded. "Yes, Justice Barrett." She produced a printed email thread, obtained through FOIA, between two Department of Homeland Security officials discussing strategies to use national security urgency as a workaround for due process requirements. She handed it to the clerk, who passed it to the bench. Barrett raised an eyebrow as she read it. So did Justice Gorsuch. Thomas interrupted again. "Emails are circumstantial. Are you accusing the government of deliberate constitutional evasion?" "I'm not accusing," Michelle said. "I'm demonstrating. When the seizure process begins before probable cause is established, when no judicial review occurs, and when FOIA documents confirm intent to avoid procedural safeguards, we move from negligence to pattern." Justice Thomas hesitated. He was not easily impressed. But he was now, at the very least, engaged. Michelle pressed on. "This case is not about a building. It's about precedent. If the court upholds this action, it opens the door to future seizures, libraries, schools, even homes, justified by vague administrative suspicion rather than individualized evidence." Her voice softened. "This isn't abstract. It's the lived reality for many Americans. Communities of color, immigrant neighborhoods, low-income districts, these are the testing grounds for constitutional erosion." Sotomayor visibly nodded now. Michelle concluded this segment with a quote from Justice Hugo Black, "Great nations are not preserved by ignoring liberties, but by enforcing them, especially when it is inconvenient." The chamber remained silent. Justice Thomas looked down at his notes. What had started as a confrontation now hovered on the edge of a transformation. The justices weren't just listening. They were re-evaluating. Michelle Obama stood still. Not a former First Lady. Not a guest speaker. But a citizen scholar standing before power, and holding her ground. Justice Neil Gorsuch was the next to speak. His voice, calm and deliberate, cut through the chamber like a measured blade. "Mrs. Obama," he began, "you've presented historical documentation and evidence of procedural avoidance. But I must ask, are you advocating for a new constitutional test or simply a stricter enforcement of existing protections?" Michelle glanced down at her notes, though it was clear she didn't need them. A stricter enforcement, Justice Gorsuch, she said. But also a recalibration, one that aligns enforcement mechanisms with original constitutional meaning. She paused. I propose a three-part test. First, the government must establish a direct and substantial link between the property and alleged criminal activity. Second, in the absence of criminal charges, a clear and convincing burden of proof must be met. Third, a judicial review must occur within 72 hours of any seizure to validate both necessity and proportionality. There was a brief silence as several justices scribbled notes. Chief Justice Roberts glanced at Thomas, then at Barrett, then leaned into his microphone. Mrs. Obama, he said, you are aware, of course, that implementing such a test would overturn large sections of current civil enforcement statutes. I am aware, Chief Justice, she replied evenly. And I'm also aware that the alternative is a precedent that allows the erosion of the Fourth and Fifth Amendments through administrative interpretation. The room stirred. Behind her, the government solicitor, David Langley, stood abruptly. Your Honors, he said, voice tight with frustration, we cannot allow courtroom theatrics to obscure the legal reality. The seizure in question was carried out under the authority of the Homeland Enforcement Powers Act of 2003. That statute passed constitutional review, twice. Michelle turned. Respectfully, Counselor, she said, the statute passed review under conditions where no direct constitutional challenge was made. This case changes that. Justice Thomas raised his hand slightly, silencing Langley. Let her continue. Michelle's eyes locked with his for a brief moment. It wasn't defiance. It was permission granted, and respectfully accepted. She turned to the bench. We have reached a moment, she said, where emergency powers have outpaced constitutional review. What we need now is not new doctrine, but restored discipline. Justice Kagan leaned forward. And do you believe the court is ready to enforce such discipline? Even if it means undermining law enforcement prerogatives? Michelle didn't blink. I believe the court has no greater duty. Justice Samuel Alito, who had been quiet until now, crossed his arms and spoke with open skepticism. You keep invoking original meaning, Mrs. Obama. But the Constitution also evolves. We are not frozen in 1791. Michelle met his gaze calmly. Indeed, Justice Alito. But the protections granted in 1791 were not time-bound, they were time-tested. We have expanded liberty, not contracted it. We've grown more inclusive, not more permissive of government power. She paused. And if evolution justifies erosion, then the Constitution becomes meaningless. Several justices looked up at that. From the back row, a law professor from NYU typed furiously into her laptop. On Twitter, screenshots of Michelle's proposed test were already trending under #ConstitutionalReset. Legal blogs were posting live updates. An op-ed headline on The Atlantic, published minutes before the scene ended, read, Michelle Obama is giving the lecture the court never knew it needed. Back in the chamber, Justice Sotomayor leaned into her mic. Mrs. Obama, I would like to revisit your citation from Boyd v. United States. That case emphasized privacy protections. How do you reconcile that with the government's interest in preempting threats? Michelle responded smoothly. The same way the founders did, Justice Sotomayor. With restraint. The state can act, but only when it proves necessity, not mere suspicion. Barrett scribbled something down. It was clear now, the room had shifted. No longer a challenge to a celebrity. It was a deliberation over constitutional limits, and Michelle Obama was steering it. As she closed her folder and took a brief sip of water, the court fell into a strange silence. The kind that precedes something historical. Not a word had been spoken about politics. Not about fame. Not even about race. Only law. And in that moment, Michelle Obama had become something more than an advocate. She had become a voice the court could not afford to ignore. Outside the marble steps of the Supreme Court, the air crackled with electricity. Protesters, supporters, students, and journalists packed the plaza. Dozens of makeshift signs bobbed in the air, due process equals justice, property rights are civil rights, and most notably, let her speak. Inside, the courtroom remained silent, but the silence had a different weight now. Justice Brett Kavanaugh shifted in his seat. He had listened without interruption for over an hour, and now he cleared his throat. Mrs. Obama, he began, your arguments are detailed, compelling, and deeply researched. But I worry about implications. If we accept your framework, do we not risk hamstringing federal agencies in times of urgent threat? Michelle's gaze remained steady. No, Justice Kavanaugh. We reign in unchecked authority. Urgency does not negate constitutionality, it demands it. She opened a new document. This is a 2021 memo from the Department of Urban Security, recommending the temporary seizure of over 100 properties flagged for potential dissident organizing, without any individualized evidence. This document was classified until leaked last year. Not a single seizure was reviewed by a judge. A ripple of discomfort moved across the bench. Justice Barrett leaned back slightly. Justice Thomas stared down at the memo in front of him. For the first time, he didn't speak. Chief Justice Roberts finally broke the tension. "Mrs. Obama," he said, "your appearance here has triggered a national conversation. Your legal claims have merit. But there is a practical concern. If we rule in your favor, thousands of past forfeitures might be challenged retroactively. How do you propose we handle that?" Michelle stepped forward. "By applying the ruling prospectively. This court has the authority to issue a forward-looking constitutional clarification. Existing seizures stand unless appealed through existing procedural routes. But this court must declare the constitutional line, or risk erasing it entirely." She let the words hang. Then added, softly, "Justice delayed is justice denied, but justice erased is justice destroyed." Behind her, the gallery was filled with quiet gasps and scribbling pens. Some had tears in their eyes. Even the court stenographer paused for a heartbeat before resuming. In New York, law students watched the live stream and began organizing teach-ins. In Oakland, a community group that had lost its cultural center under civil forfeiture began preparing an appeal. On Capitol Hill, 3 senators issued a joint statement supporting Obama's legal framework. This was no longer just a case. It was a cultural turning point. Inside the chamber, Justice Gorsuch flipped through her brief again. "On page 38, he said, "you draw a parallel between this case and Ex parte Milligan. That's a bold move." Michelle nodded. "It was a bold case, Justice." She quoted from it, "The Constitution of the United States is a law for rulers and people, equally in war and in peace." Justice Elena Kagan smiled faintly. Michelle continued, "If Milligan could be protected from military tribunal during wartime, then surely American citizens deserve judicial review before losing their homes during peacetime." The courtroom froze in reverence. Justice Thomas now broke his long silence. He didn't speak to challenge, but to clarify. "Mrs. Obama," he said, "your brief argues that due process and the takings clause are not separate protections, but interwoven. Are you suggesting this court has erred in treating them independently?" Michelle looked directly at him. "Yes, Justice Thomas. Because when the government takes property without a hearing, it doesn't just violate due process. It violates why process exists, to prevent unjust takings." Her voice lowered. "This court has the chance to unify those protections, not as competing doctrines, but as one constitutional shield." Justice Barrett wrote something down quickly. The clerk beside her glanced over, then looked away. At that moment, Justice Sotomayor leaned into her mic. "I have no further questions, Mrs. Obama." It was a quiet signal, but a powerful one. It meant she was convinced. Michelle closed her folder. She looked to each justice, one by one. Not pleading. Not demanding. Simply holding them to their own standard. Outside, the crowd erupted, not in cheers, but in sustained silence, as word of her closing had been relayed via live tweet. This court must not choose convenience over constitution. Inside, the justices sat with the gravity of what had unfolded. The hearing was over. Now came the reckoning. 2 weeks later, the nation held its breath. It was just past 10 a.m. when the United States Supreme Court issued its opinion in United States v. Atlanta Freedom Collective. Crowds had gathered once again on the court steps. Every major news network was live. Cable crawls flashed a single line across the bottom of the screen. SCOTUS rules 6-3 in landmark civil liberties case. Inside the courtroom, Chief Justice John Roberts delivered the majority opinion. His voice, steady but deliberate, reflected the gravity of the decision. "This court," he said, "recognizes that civil seizure, when executed without charge or hearing, undermines the core principles of both due process and property protection enshrined in the Constitution." He paused, glancing at the bench to his right. "The Constitution does not permit the government to bypass judicial scrutiny in the name of expediency, especially when such actions disproportionately impact vulnerable communities." Gasps echoed across the room. On social media, hashtags exploded. Hashtag Obama Doctrine. Hashtag SCOTUS Reform. Hashtag Constitution Strikes Back. The opinion continued. "Accordingly, we adopt a 3-part framework, as proposed during oral argument, to govern future civil seizures. 1. A direct and substantial link to alleged criminal activity. 2. Clear and convincing evidence if no criminal charge is filed. 3. Mandatory judicial review within 72 hours. Reporters scribbled, then stopped, no longer able to keep up. Justice Sotomayor issued a concurring opinion, highlighting the racial and economic inequities of current forfeiture practices. Justice Barrett's concurrence was more surprising. She wrote, "Though I came to this case skeptical, I leave it reminded that constitutional vigilance is not the enemy of order, but its guardian." But perhaps the most stunning development came in the form of a footnote, one that would be cited in law reviews and classrooms for generations. The court commends the amicus brief and oral presentation submitted by Mrs. Michelle Obama, whose historical analysis and doctrinal clarity were instrumental in shaping this decision. A wave of emotion surged through the courtroom. In the gallery, a law professor from Howard University wiped a tear from his cheek. On Twitter, a Georgetown law student wrote, "I just watched a First Lady change constitutional law." At home, Michelle Obama watched from her office, alone, quiet, unmoved. Her phone buzzed relentlessly. Invitations from law schools, editorial boards, even international courts flooded in. But she didn't answer. She simply highlighted a paragraph from the court's decision and placed a sticky note on the page. It read, "The law speaks loudest when the unheard are finally heard." By noon, headlines had crystallized. Michelle Obama's brief becomes law. The day the Constitution fought back. From First Lady to first principles. Across the country, communities began preparing legal challenges based on the new framework. Seized cultural centers, churches, homes, and community clinics saw a path to reclamation. Within days, the American Bar Association announced that its next annual conference would feature Michelle Obama as keynote speaker. At Harvard, Yale, and Stanford, professors overhauled their constitutional law syllabi to include United States v. Atlanta Freedom Collective, with a special week dedicated to the oral argument by Amicus Obama. And in Washington, a quiet, profound shift occurred. Lawmakers introduced bipartisan legislation codifying the court's new test into federal statute. But perhaps the most enduring moment came 3 weeks later, when Michelle Obama received a handwritten note, delivered by Supreme Court courier. It read simply, "Your words reminded us of ours. Jr." She didn't smile. She nodded. Because for her, this wasn't a victory parade. It was a restoration. And now, the work of protecting that restoration had only just begun.